Good morning, everyone. Good morning to all the students who have joined the class. So today we are going to cover the topic of the indemnity and guarantee. Good morning, bache. Good morning, Amit. Okay. So meanwhile, the other students will join. Okay. Good morning, Soumya. Good morning, Ashish. Good morning, Krish. Good morning, Shalini. Okay, the students have started joining the class. Good morning, Avdesh Singh. Good morning, Noor, Himanshu. Namaste, Himanshu. Good morning, Manyata. Good morning, Amit. Okay, so the students are joining the class now. We will be starting with the topic. Good morning, Samir. Okay, so we will be starting with the indemnity and guarantee. This is the topic of the Indian Contract Act only. So because this is a topic of the Indian Contract Act only, so this is also a type of the contract, not a general type of the contract. This is the indemnity contract or the guarantee contract. So because this is further a specific type of the contract, so all the essentials of the contract will definitely get first fulfilled. Then after, we will move on to whether this contract is the indemnity contract or the contract of the guarantee. Right? Good morning, Kaushal. Good morning, Kavita, Utkarsh. Good morning, Indresh. Good morning, Sakshi. And good morning, Prince. So, हमने जो आज टॉपिक शुरू किया है वो इंडेमनिटी एंड गारंटी का टॉपिक शुरू किया है जिसमें हमने वी हैव जस्ट डिस्कस्ड that because this is the part of the Indian Contract Act only, all the essentials of the contract, that when the contract can be a valid contract, all the essentials of section 11 first will definitely get fulfilled. Only then we can say this is a contract or not. Now further, this contract is the contract of indemnity or the contract of guarantee, just like we have other type of specific contracts also, just like we have agency, we have bailment, we have indemnity, and we have contract of guarantee also. Now, why these specific names are given? Because in indemnity and guarantee, its name depicts that for what purpose this contract must have been made. So, while understanding what is indemnity and what is guarantee, you will definitely come to a conclusion that, okay, this was the contract only. All the essentials of the contract first obviously need to get fulfilled. Further, we have to see कि वो contract indemnity का है कि guarantee का है कि bailment है, agency है. So these type of the specific contracts. So because this name is given, this name is specifically given, these names are specifically given to just see if it will be written, okay, this is a contract of indemnity, a person will definitely at that very moment get to know about that what must be the purpose of forming this contract. So उस contract को बनाने का purpose क्या होगा ये उसके नाम से ही पता चल जाता है. जैसे कि यहाँ पे अगर कोई कंट्रैक्ट ऑफ इंडेमनिटी बोलेगा या कंट्रैक्ट ऑफ गारंटी बोलेगा तो बाय द एंड ऑफ टुडेज क्लास ओनली यू विल डेफिनेटली एबल टू आंसर कि कंट्रैक्ट ऑफ इंडेमनिटी क्या होता है. So let's start with contract of indemnity first. So we will be covering unit 7 in 2 classes, today's class and one more class. And in 2 classes, we will be covering the topic of the contracts of indemnity and guarantee. Now here you also see what is written, contracts of indemnity and guarantee. So first it will be a contract. Then we will see it's an indemnity or a guarantee. Okay, so in these unit 7, we will be covering sections 124 to 147. Now this 124 to 147 covers the subtopics. So 124 to 125 talks about what contract of indemnity is. कंट्रैक्ट ऑफ इंडेमनिटी होता क्या है, ये 124 एंड 125 से आपको पता चल जाएगा, जिसमें कि डेफिनेशन दी गई है, पार्टीज दी गई हैं। नेक्स्ट 126 एंड 127 से आपको पता चल जाएगा कि कंट्रैक्ट ऑफ गारंटी क्या होता है और उसमें पार्टीज कौन सी होती हैं। नेक्स्ट, in section 128 you will get to know about that there is one party known as the surety in guarantee. In section 128 you will get to know about the liability of the surety. 129 to 132 will be talking about the continuing guarantee, and further in 133 to 139 we will be talking about when the surety can be discharged, in what circumstances we can discharge the surety from his liability. And in 140 to 147 you will be knowing about the rights of the surety. जो surety है, अगर हमने उसको liability दी है तो उसको हमने rights भी दिए होंगे. So whenever you talk about law सिर्फ आपको एक चीज के लिए liable नहीं ठहराता, आपको rights भी साथ में देता है. So further moving on to this picture, the contract of indemnity. This picture shows two cars clashing with each other. Now, why this picture has been pasted on the with the title, you will be definitely understanding once you will get to know about what contract of indemnity is from the further slides. Then we will come back to this slide and you will definitely understand why these two clashing cars picture has been pasted on this title page, on this heading page. Now, what indemnity means? Indemnity means if some party is about to suffer from some loss, if some party, any of the person, some party is about to suffer from some loss, and we say we will protect you from that loss. Don't worry, we will definitely protect you from that loss. Indemnity means, indemnity comes from the dictionary means indemnify. Indemnify करना means किसी को compensate कर देना. अगर किसी को कोई loss हुआ है तो we should compensate the loss, ताकि जिसको loss हुआ है वो उस चीज के लिए आगे proceed with कर सके. So for example, अगर मुझे कोई कह रहा है तुम ये काम करो, डोंट वरी, जो भी तुम्हें लॉस होगा हम तुम्हें कंपनसेट करेंगे, तो डेफिनेटली आई विल go for that work, because I will not have the fear in my mind that if I will suffer the loss. ओके अमित, आई एम ट्राइंग, बच्चे मैं हिंदी और इंग्लिश दोनों में एक्सप्लेन करूं. सो सिक्योरिटी अगेंस्ट लॉस, जब मुझे लगे कि मेरे को लॉस हो सकता है तो मैं उस चीज के लिए एफर्ट थोड़े कम करूंगी. So because I will have a fear in my mind that if I'll suffer a loss from that thing, then so if some person is providing security to you that if so ever you will suffer loss, your loss is secured because we will be compensating the loss to you. So it can be said that indemnity is security against the loss. और अगर किसी को लॉस हुआ है तो हम उसको उसके लॉस को गुड कर दें, मतलब उसको एक ऐसी सिचुएशन में ले आए एज इफ द लॉस नेवर हैपेंड. इसी को हम एक और तरीके से भी बोल सकते हैं. सो वी कैन एक्सप्लेन इट इन द अदर वे आल्सो, दैट टू कंपनसेट द पार्टी हु हैज सफर्ड सम लॉस. So if some party has suffered some loss and you promise to that party that don't worry, your loss will definitely get compensated. In that case, you are just promising the other party that don't worry, we will indemnify you. Whatever will be the loss, we will indemnify you. Nandini, we will be definitely going to the insurance part in the indemnity also. But first, हम basic देख लें कि indemnity क्या है. बाद में insurance is a contract of indemnity or not, or in which category it can fall. ये हम आगे पढ़ेंगे. Definitely, we will be covering this insurance point. Yes, Khadija, we will definitely covering this example of insurance. It's a very apt query which is coming in the mind of all of you, right? So we will be definitely covering this. Okay. Um, Okay, Latha, I am trying to explain it in English also, but because there are some people, some students who want to understand it in Hindi also, so I'll be repeating it in Hindi also, right? But definitely, if you will get any problem, I will again repeat it in English. Don't worry. So it's just the way of saying that it is the security against loss, it is to make good the loss, or it is to compensate the party who has suffered some loss. It's the one and the same thing, but it's just it is just explaining it in the other ways also. Right? So indemnity means to compensate the loss of the other person. Coming to the definition. What definition the 124 section of Indian Contract Act 1872 has given for the contract of indemnity? Now you will see the definition of indemnity has been given in the Contract Act only, but it is section 124 because in the first sections they are explaining what contract is, what will be the essentials. So the general contract meaning has been explained in the first sections. Then we moved on to the specific types of the contract, and in section 124 it was a turn of the contract of the indemnity, where the definition of contract of indemnity has been given. So section 124 में indemnity की definition दी गई है Indian Contract Act 1872 की. Now what it says? It says it's a contract only. When we started the lecture, when we started the session, I told you that it should be first a contract. Then only we can think that it's the contract of indemnity or not. So first it should be a contract. That is, the essentials should get fulfilled first to make it a contract. Because otherwise it will just remain a promise or the agreement. If you have to form it a contract, you have to fulfill the essentials. So once a contract is made, then we will see which specific type of contract it is. Maybe it is a specific type of contract, maybe it not, maybe it is just a general type of the contract. So here we are talking about the specific type of the contract, that is the indemnity. Nandini, we will be I mean, can we consider insurance as one? Yes, Nandini, I will be answering your question, bache. Just wait for the other slides, for the further slides to come. I will be definitely covering your point, and I will be explaining it properly. Don't worry for that. But sections are not missing. Pavan Kumar, sections are not missing. Bache, we have just started with section 124, and from section 124 only indemnity starts. Aman Gupta is asking, can we consider third party insurance as indemnity? Aman, again, I'll be just saying this thing only. Just wait for a few minutes. We will be definitely moving on to what insurance will be and what all will be covered in the insurance or not. Right? Okay. Now, coming to the indemnity part. They say, we have just discussed that indemnity means to compensate the loss. That's the security for the loss. To make good the loss. Now, to whom you want to compensate? What contract it is? It says a contract by which one party promises to save the other. So as we know, before forming a contract, we form a promise. And in promise, A person who does a promise is a promiser, and a person with whom this promise is made is a promisee. So, a person who promises, that is a promiser promising with the other. That don't worry. Promise is what promise? A contract by which one party promises to save this another from any loss. Might be this person will suffer. Might be this person will suffer. So a contract by which one party promises this second party to save the other. सेकेंड पार्टी को सेव करने का प्रॉमिस करता है फ्रॉम लॉस. कौन से लॉस से? अगर इस सेकेंड पर्सन को जिसके साथ प्रॉमिस किया है कोई लॉस होता है, किसकी वजह से? जो प्रॉमिस कर रहा है उसकी वजह से, या फिर किसी और थर्ड पार्टी की वजह से अगर इसको लॉस होता है, तो कौन कंपनसेट करेगा? दिस प्रॉमिसर विल कंपनसेट. इट मीन्स दैट इज द कंट्रैक्ट ऑफ इंडेमनिटी. So, agar if one party promises with the other party that if this other party will suffer from any loss, if this other party will suffer from any loss, kaun sa loss? Not any loss. Loss which will be caused by this promiser who is promising, or the loss which will be happening to this person because of the third party. So, indemnity means one party promises with the other that if you will suffer any loss because of me or because of this third person, any of the third person, I will definitely compensate you. I will make good the loss whichever you will suffer. So, this is the contract of indemnity. जैसे कि यहां पे you will see the image where there's a theft with a person, but there's a theft, right? Now अगर किसी person के घर पे चोरी हो जाती है, theft हो जाता है, and this person must have taken insurance from some company. तो अगर ये चोरी हो जाती है तो ये इंश्योरेंस कंपनी उस पर्सन को कंपनसेट करेगी. अब इसमें आप देखो लॉस किसकी वजह से हो रहा है उस पर्सन को? थेफ्ट की वजह से, इस थर्ड पर्सन की वजह से. और कंपनसेट कौन कर रहा है? प्रॉमिसर. सो दिस इज द सेकेंड पार्ट हियर इन द डेफिनेशन. व्हाट? वेयर दिस प्रॉमिसर must have promised with one person that if because of any third person, this thief, any third person, you will suffer loss, I will compensate you. So here this insurance company, insurance person will compensate that person. That is the, so this insurance person is the promiser who just have promised with someone that if you will suffer loss because of any third person, that can be thief also, I will compensate you. So I will be giving you the other examples also. So if I'll just refer the examples from your own study material. The first example given is A contracted with the government. A ने government के साथ contract किया that please give me funds to go to the abroad and study. Please give me funds to go to the abroad and study. I'll return back to India and serve the government for 5 years. So here, a person who is saying that please give me funds, I'll go to abroad and study and will come back to India and I will use those studies and serve the government for the 5 years. I will definitely come back to India. Government gave the funds to A and A studied there. Now, A is not coming back. But when he took the funds from the government, he promised that if I will not come back, I will make good the loss. I will compensate you. So now A studied there, never came back. But now A studied there, but never came back. So the promise, the contract of indemnity A entered with the government was, if I will not come back, I will compensate to you. If I will not come back, I will compensate to you. It means now if because A is not coming back, A has to compensate to the government. Now here, a person promising, that is the promiser is A, who promised with the government that if I will not come back, you will suffer losses, I will compensate it to you. Now A, promiser, is compensating to the third party. For the loss, this A is compensating the government, is compensating the other. For the loss, the government has suffered because of the promiser himself, because he never came back and served the government. So here, a loss is being compensated to the other party, which has happened because of the promiser himself. So this is the example of where one party promises to save the other from the loss caused to him by the conduct of the promiser himself. And if I take the example of the second point written here, a contract by which one party promises to save the other from loss caused to him by the conduct of any other person. So if this loss would have been made because of the conduct of any third person also, that can also be contract of indemnity. Just like in this example, I have told you that in this, the loss is happening to, suppose, A's house. The theft has been committed in A's house. So loss has been suffered by A. And the promiser and A already entered into some contract where this promiser insurance company promised with A that if so ever you will suffer loss because of any third person, I will compensate you. So now this third person is the thief here. So if this loss took place because of the third party also, this promiser, this insurance company will definitely compensate the A, that is the promisee, that is the other person with whom the promise is made. Yes. Anybody is having any doubt, बच्चे? Okay, Aryan. I hope आपको आगे भी समझ आता रहेगा, बच्चे. Any doubt to anyone, बच्चे? So make sure to understand one thing. The compensation of loss, the loss which has happened because of the fault of the promiser himself or because of the third party, that will be the contract of indemnity. Now parties to contract. As we have already discussed, there must be two parties, the promiser who promises and the person with whom the promise is made that don't worry, your loss will definitely get compensated. So who will be the parties to contract? A person who promises is a promiser. In the same way, in the contract of indemnity, it will be the indemnifier. So promiser will be the indemnifier, right? So who is the indemnifier? The party who promises that don't worry, I am standing behind you. If you will suffer some loss, I will be there to compensate you. You go ahead. The person who promises is the indemnifier, and the person with whom the promise is made, a person who has been given a sigh of relief that don't worry, I will be there. That person who is indemnified is known as indemnified or the indemnity holder, that I hold the indemnity. If I'll suffer loss, I will be indemnified. So indemnifier is a person who promises to indemnify or save the other party, and the other party with whom the promise has been made to save that person is the indemnified or the indemnity holder. Okay, Kaushal, I have already uploaded. Bache, you can check it. Ma'am, Pavan Kumar is asking, ma'am, can we call indemnifies as insured? पवन कुमार, इसके लिए आपको थोड़ा सा और वेट करना पड़ेगा. हम इस चीज को, इंश्योरेंस के कंसेप्ट को बहुत अच्छे से आगे जाके थोड़ा और वाइडली पढ़ेंगे. ठीक है. ओके. हिमांशु, हिंदी में आपको सिर्फ ओके मैं समझाती हूँ. पार्टीज टू कंट्रैक्ट का मतलब, पार्टीज टू कंट्रैक्ट ऑफ इंडेमनिटी. इंडेमनिटी का मतलब जैसे आपको समझ आया है, इंडेमनिटी में क्या होता है कि मान लो मैंने किसी को बोला कि तुम, अगर तुम्हें लॉस होता है तो मैं तुम्हें कंपनसेट कर दूंगी, मैं तुम्हारी भरपाई कर दूंगी. लॉस किसकी वजह से हुआ? मेरी वजह से हुआ, या फिर किसी और थर्ड पार्टी की वजह से लॉस हुआ, तो मैं तुम्हें कंपनसेट कर दूंगी, मैं तुम्हें भरपाई कर दूंगी. दिस इज द कंट्रैक्ट ऑफ इंडेमनिटी बिटवीन मी एंड दैट अदर पर्सन. प्रॉमिस किसने किया? सेव करने का, इंडेमनीफाई करने का मैंने. तो मैं होंगी इंडेमनीफायर. जिसके साथ मैंने प्रॉमिस किया वो होंगे इंडेमनीफाइड और द इंडेमनिटी होल्डर. इसकी एग्जाम्पल करते हैं. ए promises with B that I will deliver you goods for rupees 2000. A promises with B that I will be delivering goods of rupees 2000 to you. C comes in and promises to indemnify B's losses. C इस इनके साथ बीच में आता है and says that B को कहता है to indemnify. C comes in and promises to indemnify B's losses if A fails to deliver the goods. So basically अगर A goods B को डिलीवर नहीं कर पाया तो लॉस किसको होगा? B को. तो C B को कहता है कि अगर ये थर्ड पार्टी A तुम्हें गुड्स डिलीवर नहीं करेगी तो तुम्हें लॉस होगा. तो इंडेमनिटी में लॉस चाहे मेरी वजह से हो चाहे ए थर्ड पार्टी की वजह से हो, मैं तुम्हारी भरपाई करूंगा. अब यहां पे लॉस अगर होगा तो किसकी वजह से होगा? ए की वजह से होगा, इफ ही विल नॉट डिलीवर द गुड्स टू बी. नाउ they say this is how B and C will enter into a contract of indemnity where C who promises that if A will not deliver, I will indemnify you. So the promise is made by C to B that if you will suffer losses, because if A will not deliver you the goods, you will definitely suffer losses. But don't worry, if you will suffer loss because of this third person, that is A, I will indemnify you. So the contract of indemnity is between C and B, where C promises with B, I will compensate you, that is B, if you will not be receiving the goods from A. Because I know if you will not be able to receive the goods from A, you will definitely suffer losses. But don't worry, I will compensate the losses to you. So here the person who is promising to compensate is C, and the person with whom the promise has been made is B. Now this is the example where the loss must take place if A will not deliver. That is because of the fault of the third party. Any doubt to anyone? Okay, Prince Padyar, ma'am, if loss due for natural calamities, so section 124 apply or not? Prince, again, bache, this will be covered in the next 4-5 slides only, because the topic of insurance, the contingency, so just like you have put up the doubts regarding the natural calamities, that will be covered under the contingencies. So I will be definitely covering it. Just wait for some time. मैम, अगर हम उसके नुकसान की भरपाई ना करें तो वो पर्सन हमारे खिलाफ क्या क्या एक्शन ले सकता है, आगे पढ़ेंगे. हिमांशु थोड़ा सा वेट करना पड़ेगा बच्चे, बिकॉज अगर मैंने बीच में वो करा दिया तो आपका सारा लिंक, बाकी बच्चों का भी लिंक खराब हो जाएगा। ओके। थोड़ा सा प्रिंस, थोड़ा थोड़ा आंसर आपको इस स्लाइड से मिल जाएगा, बट वाइडली वी विल डिस्कस इट इन द नेक्स्ट स्लाइड्स। ओके। इंडेमनिटी, जो कंट्रैक्ट ऑफ इंडेमनिटी है, इसका स्कोप थोड़ा सा लिमिटेड रहता है। व्हाई? बिकॉज they have specifically told in the definition also that if this loss will happen because of the promiser himself who is promising with you, okay, I'll compensate. So this loss or the loss which will take place because of the fault of some third party, because of the fault of some third person, except these two people, if this loss will happen, this will not be covered under indemnity. This is very exhaustive. Exhaustive means बस इतना ही cover होगा. Illustrative means this is just the illustration, you can cover more. But this is exhaustive. They have specifically told only because of the fault of the promiser himself or because of the fault of some third party. Now, they say the contract of indemnity is having a very limited scope because it is not covering these losses. Which losses? They say if this loss will take place because of the conduct of the promisee with whom the promise is made, that is the indemnified. If this loss will happen because of the fault of the indemnified, they will not cover. So basically they say that if a person who is indemnified, if he himself causes a loss, they said it will not be covered. You are causing loss for yourself. Why will you get compensated for this? So for example, A promises with B, if loss will happen to you because of me or because of third party, I will compensate to you. Genuinely, if this loss will be done by indemnified himself, it should not be compensated. You will create the losses for you and expecting that the indemnifier will compensate you. No, it is not possible. You will keep on doing the losses then. So indemnified, if doing loss by himself, he will not get compensated. So this is not covered. That is by the conduct of promisee. If the loss has happened, you will not get compensated. By an accident, not caused by any person. Not caused by any person. मतलब अगर कोई लॉस इंडेमनिफाइड को हुआ जो कि किसी ह्यूमन एजेंसी की वजह से नहीं हुआ, तो वो यहाँ पे इंडेमनिटी में कवर नहीं होगा. सो पवन कुमार, आपने नॉट पवन कुमार, यस प्रिंस पध्यार ने क्वेश्चन पूछा था कि अगर नेचुरल कैलेमिटीज की वजह से लॉस हो तो नेचुरल कैलेमिटीज की वजह से अगर लॉस हो तो वो क्या कहलाएगा? that loss has not occurred because of the human agency. That loss has occurred because of some natural calamity. इसी को ही थोड़ा और एक्सप्लेन करते हैं. by an act of the god, any act of the god. कोई फ्लड्स आ गए, कुछ अर्थक्वेक आ गया, these are the act of the gods. So simply indemnity covers only the loss which has taken place because of the fault of the promiser himself or because of the third party. So, nutshell, I can say that indemnity means to compensate the loss which has happened because of the human agency only. That is not because of any natural calamity, not because of any act of the god, not because of an accident which is not caused by any person. So if this loss has not happened because of the human agency, definitely it is not the indemnity. And now further, in human agency also, it should be only promiser or because of the fault of the third party. Because of the fault of the promisee himself also is not covered under the indemnity. But In the case of Gajanan Moreshwar versus Moreshwar Madan, it's a judgment of 1942. Decision was given taking the English law into consideration. And what they said, that indemnity means just a promise to save the another, harmless from the loss. Open definition. Now this is the open judgment कि अगर आपको लॉस हुआ तो अगर आपको लॉस होने की भरपाई का प्रॉमिस किया गया तो वो इंडेमनिटी होगा. ठीक है, इंडेमनिटी होगा, लेकिन वो इंडेमनिटी अकॉर्डिंग टू 124 तो होगा अगर ये लॉस आगे किसकी वजह से हुआ हो, प्रोमिसर हिमसेल्फ या फिर थर्ड पार्टी की वजह से ये लॉस हुआ हो. सो इसीलिए उन्होंने, क्योंकि इंग्लिश लॉ को कंसिडर करके जजमेंट दी थी, द इंग्लिश लॉ वाज कंसिडर्ड व्हाइल गिविंग द जजमेंट बाय द जजेस इन द गजानन मुरेश्वर वर्सेस मुरेश्वर मदान. They specifically normally said that if there is a promise to save you from the losses, it will be indemnity. Even if it means that every loss will be covered, even if it is covered, if the loss has happened because of the negligence of promisee himself, this is the negligence of promisee. This is the negligence of promisee. Because of the negligence of promisee himself, or by natural calamity, or by accident. So basically, these three things which we are not covering under the definition of the contract of indemnity, Gajanan Moreshwar versus Moreshwar Madan, took the meaning from the English law and included all these things. But according to our Indian Contract Act, it is only the laws which must took place because of the promisor himself or because of the third party. तो हमारे इंडियन कंट्रैक्ट एक्ट के अकॉर्डिंगली इंडिया कंट्रैक्ट ऑफ इंडेमनिटी में सिर्फ वही लॉस कवर होता है जो प्रोमिसर की वजह से हुआ हो या फिर थर्ड पार्टी की वजह से हुआ हो. गजानन मोरेश्वर वर्सेस मोरेश्वर मदान की जजमेंट दो इंडियन जजमेंट है, 1942 में दी गई थी, बट उन्होंने इंग्लिश लॉ को फॉलो करते हुए ये तीनों चीजों को इंक्लूड कर दिया था. कि अगर इन तीनों की इंक्लूड कैसे कर दिया, क्योंकि नॉर्मल बोल दिया अगर कोई प्रॉमिस है जिसमें लॉस की भरपाई होगी तो वो इंडेमनिटी होगा. कौन से लॉस की, ये कुछ नहीं बोला. तो इसका मतलब उन्होंने सब कुछ कवर कर दिया था. लेकिन हमारा इंडियन कंट्रैक्ट एक्ट की डेफिनेशन यही कहती है इंडेमनिटी की कि हम अगर ये लॉस प्रॉमिसी की वजह से हुआ हो या फिर कोई ऐसे एक्सीडेंट की वजह से हुआ हो जिसमें ह्यूमन एजेंसी इन्वॉल्व ना हो या फिर किसी एक्ट ऑफ द गॉड की वजह से हुआ हो, तो वो जो लॉस है वो अगर उसका प्रॉमिस कवर का प्रॉमिस होगा तो वो कंट्रैक्ट ऑफ इंडेमनिटी नहीं होगा. सो यहां पे हम एक और चीज को ओके खाटीजा बच्चे, आई हैव जस्ट एक्सप्लेन इट दैट ओनली कि अगर कुछ नेचुरली होता है तो वो इंडेमनिटी में कवर नहीं होता, बिकॉज that must be covered in this second category, that by an accident not caused by any person. So if it is that, in that case it will not be the indemnity. In which way party compensate, that can be the monetary compensation, that can be the other type of the compensation also, whatever has been discussed between them. ओके आगे चलते हैं. यहां पे हम एक छोटा सा पॉइंट डिस्कस करेंगे. हमारे पास एक कंट्रैक्ट ऑफ कंटीजेंसी कंट्रैक्ट होता है, कॉन्टीजेंट कंट्रैक्ट. यू मस्ट हैव रेड इट बिफोर ऑल्सो. कंटीजेंट कंट्रैक्ट क्या होता है, जो किसी कंटीजेंसी की वजह से हुआ हो. कंटीजेंसी मीन्स विच मे हैपन, विच मे नॉट हैपन. तो यहां पे इन द इंडेमनिटी ऑल्सो द लॉस may happen because of the promiser or the third party, may not happen. So if it will happen, the loss will be compensated to you, and if the loss will not take place, the loss will not be compensated to the indemnified. Is that okay? Is that okay? Yes or no? I'm just repeating it again. So if I'll say the contingent contracts, it means if this loss will take place, I will compensate to you. And if this loss will not take place, I will not compensate it to you. So now it depends upon the contingent thing, contingency. कि अगर वो हुआ, अगर लॉस हुआ तो आपको कंपनसेट कर दिया जाएगा, और अगर लॉस नहीं हुआ तो आपको कंपनसेट नहीं किया जाएगा. इट्स द सेम एज just like the contingent contracts. Yes or no? Yes. What about others? Okay, Shoaib said yes. What about others, bache? Yes, because here again it's a contingency. Might be that loss will happen, might be that loss will not happen. So how will you say that this is the contingent contract or the contract of indemnity? Or both? Okay, students who were having the doubts of insurance, I am going to cover that point now. Chaitanya said yes, ma'am. Krish said both are similar. Okay. What about others? I am waiting for the reply. Okay, Chandani, what is your answer, bache? It's the same? Yes. Okay, you have said yes. It's similar. It's same. Anybody else? Satyam, for the profit, the definition doesn't cover the name word profit. So we will just stick to the loss. If profit will occur, that will not be the contract of the indemnity, because indemnity means to indemnify. किसी की भरपाई करना. प्रॉफिट की कभी भी भरपाई नहीं होती. हम हमेशा सिर्फ लॉस की ही भरपाई करते हैं. Yes, Shoaib, you are exactly on the correct point that this is a subset of the contingent contract. Okay, Chandani Panchal, it is similar. Okay, Kaushal is saying it is same. And then Kavita is saying, ma'am, are there can be more than one party as the indemnity holder and indemnifier in... Ma'am, are there can be more than one party as the indemnity holder and indemnifier? Kavita, you have to write the question again, बच्चे. थोड़ा सा और explain करके question को लिखो. Okay, Palak Jain is saying that it is similar. Is this case law is incomplete or unjustified? Okay, Chaitanya, it is just like that the English law was considered in 1942 while discussing this Gajanan Moreshwar. So they thought that they might be, so in law what happens is the facts and the circumstances of each case is different. The facts and the circumstances of each case is different. So might be they were facing such kind of circumstances or facts of the case that they had to impose the English law. Otherwise, while the judgment is given in India, it's the lex loci, the law of the land is applicable, and the Indian laws will be applicable only. And according to it, according to the Indian law, you have to follow section 124. That is the only loss because of the promisor himself or because of the third party will be covered under the indemnity. Let's come back to the contingent contracts now. Okay. As Shoaib said, that it must be the subset of the contingent contract. Very right. Contingent contract क्या थे? Contingent contract है, if this thing will happen or if this thing will not happen, then this will take place. So the contingent contract, the performance of the contingent contracts depends upon the happening or non-happening of some event. Now this happening or non-happening can be because of the human agency or can be because of some non-human agency. So the performance of the contingent contracts depends upon the happening or non-happening of any event, By the human agency or by the non-human agency. But in indemnity, we are only covering the happening because of the happening or non-happening, because of which the loss will happen. Now, this happening or non-happening will take place because of the human agency only. So, though the contract of indemnity is a contingent contract only, but contingent contract is a wider one because it is covering the happening, the performance is dependent upon the happening or non-happening of some event, which can take place because of the human agency or because of the non-human agency. But in indemnity, we are just covering the loss, the happening, which takes place because of the human agency only. Though this indemnity also depends upon the happening, loss, which will not take place, contingent. But it's a part of the contingent contract because here the only happening will be taken place only if it has happened because of the human agency. But in the contingent contract, the happening or non-happening can be because of some natural calamity, can be because of some act of the god, can be because of the any accident not caused by any person. These are covered under the contract of contingent contracts. But in contract of indemnity, it only covers the loss, the happening which has happened because of the human agency only. So contract of indemnity is very exhaustive definition. This doesn't cover anything else except the loss which has taken place because of the promisor himself or because of the third party. So only human agency, and that too only promisor or the third party. It's a narrower definition, right? It's the subset of the contingent contract only. It covers only a part of the contingent contract, but not it. So we can say that the contract of indemnity is a contingent contract. But all the contingent contract doesn't mean it only covers the contract of indemnity. It covers many other contingencies, including the contingency which might will take place, might will not take place because of some human agency, because of some non-human agency. But in contract of agency, it is only the human agency. Is that clear? So now you will answer me. Okay, Nandini, you asked about the insurance and many other students asked me about the insurance. Now you will tell me insurance will be in contingent contract or the contract of indemnity. Krish, that we will be doing further is said to be implied. So we can make the contracts in two-way, express contracts or the implied contracts. In that, you can say that the indemnity contract can be through the express contract or the implied contract. That we'll be doing in the next slides. हाँ जी सत्यजीत, बताइए बेटे, what is your answer? Insurance will be contingent contract. Okay. Okay, Khadija, bete, winning or losing cricket match is some other kind of the contract that is not covered here. Okay, Satyam is saying it is the contingent contract. Rishikesh is saying it is both. Khadija is saying Ma'am, in contingent contract, can we take example of either winning or losing of cricket match? Khadija, this is some other kind of the contract, the example you are giving me. Contract of indemnity, Satyajit is saying, is indemnity contract, is contingent contract, but contingence is provisionally fixed to happen. Chaitanya, bete, indemnity, contract of indemnity is a contingent contract only. So I can say this thing, that indemnity contract will always be the contingent contract, but all the contingent contract cannot be said to be the contract of indemnity because it is a wider definition. It can happen because of the non-human agency also. So all the contingent contracts cannot be said to be a contract of indemnity. Okay, Khadija. Next, Nana is saying that it is contingent contract. Ayushi is saying it is contingent contract. Krish is saying that will be called wagering. Yes, bache. Okay. So this wagering, I guess, is the answer for the cricket match wala question. Whosoever put up this question, you can see these contracts. Okay. Here, Nandini said it's contingent. कुछ होना हो या ना होना हो. Mr. Sheikh said contingent as well as contract of indemnity. Okay, coming to the answer. मैंने क्या बोला था? If this must have happened because of some human agency, because of some non-human agency, it will be contingent contract. And if that has happened because of some human agency only, and that human agency must be the promisor or the third party, that will be the indemnity. Contract of insurance. ओके, कंट्रैक्ट ऑफ इंश्योरेंस पे सबसे पहले हम आते हैं लाइफ इंश्योरेंस पे. ओके, टेल मी, लाइफ इंश्योरेंस is a contingent contract or not? Life insurance is a contingent contract or not? Not. Nana said yes. Yes. No, bete. It is not the contingent contract. Kyun? Listen to me very carefully. All are answering that it is, yes, it's the contingent contract. Okay, tell me one thing. Whenever you take the life insurance policy, you pay the premium? Quarterly, 6 monthly, yearly, you pay the premium. Now this amount of insurance you will get on the happening of some uncertain event. Now this uncertain event can be through some human agency, can be through some non-human agency. But please keep this thing into the mind that in life insurance, you will definitely get the maturity amount. Only the difference is, if some person's death take place before the time of the maturity, he will get that matured amount. At the persons who are relatives, who are the legal representatives, who will be having the right to take the amount, they will take the amount when this person will die, because before that maturity period. But don't forget this thing, that if this person will not die before the maturity period, this person will himself also get the maturity amount after 10 years, 15 years, for whatsoever period he has taken the life insurance. They will definitely get the amount. Either this person dies, or if this person will not die, he will himself get it. So यहाँ पे बेटे कंटीजेंसी नहीं है. लाइफ इंश्योरेंस कॉर्पोरेशन से अगर आपने एक प्रीमियम का एक LIC ली है, उसको आपको पे करना ही पड़ता है. डिफरेंस सिर्फ ये होता है, अगर ये कंटीजेंसी नहीं होती, अगर आपकी अगर फॉर एग्जांपल ए की डेथ एक मेच्योरिटी पीरियड, फॉर एग्जांपल 15 इयर्स की उसने लाइफ इंश्योरेंस पॉलिसी ली और उसकी 10th ईयर अभी चल रहा था और उसकी डेथ हो गई, तो इंश्योरेंस कंपनी अब 10th ईयर पे ही उसके जो भी रिलेटिव्स होंगे उनको मेच्योरिटी अमाउंट देगी. बट अगर ए की डेथ 10th ईयर में नहीं होती, तो 15 इयर्स के बाद भी तो ए को खुद को भी तो पूरी की पूरी अमाउंट मिलेगी. इज दैट क्लियर? इज दैट क्लियर? राइट? ओके, सो कंटीजेंसी मीन्स इट इज कवरिंग बोथ. लाइफ इंश्योरेंस की मैंने आपको एग्जांपल बताई, बट अगर मैं आपको एग्जांपल बताऊं मेरीन इंश्योरेंस की, मेरीन इंश्योरेंस की या फिर फायर इंश्योरेंस की. अब अगर तो ये मेरीन इंश्योरेंस और फायर इंश्योरेंस दोनों में से जो भी है, अब हो सकता है मेरीन इंश्योरेंस में शिप सिंक्स इनसाइड द सी, हो सकता है शिप विल नॉट सिंक, बट इफ द शिप विल सिंक insurance company will give the compensation. But if the ship will not sink, they will not get anything. But in life insurance company, if A will die, he will get the matured amount, and if he will not die, even then he will get the amount that is after the mature period. You found the difference? In fire insurance, if fire catches your house, you will get the compensation. But if fire will not catch your house, you will not get compensation. So, can I say that marine insurance and fire insurance की अगर मैं बात करूं, that are purely contingent in nature? But if I'll say life insurance, yes, it is contingent in nature if I'll consider that A might will die before 15 years of the maturity. From that perspective, it is contingent. But if I'll say the liability will definitely take place in the case of life insurance policy, because either they will have to pay on the 10th year if A will die, or they will have to pay on 15th year when the policy will get matured. So if I'll take the perspective of the liability will definitely happen in the insurance, life insurances. But in the marine insurance or the fire insurance, liability will only happen, only take place. Liability will only take place if the ship will sink or if the house will catch the fire. So, if I'll be taking the perspective of the liability, definitely in life insurance, the liability will take place. It is not contingent from the perspective of the liability. And in marine insurance or fire insurance, it is the in marine insurance or fire insurance, the liability will take place only if this event will happen. Otherwise, these general insurance companies doesn't pay to you because you have not suffered a loss. Now, because this marine insurance, the ship will sink because of the fault of some human agency. Your house will catch fire if because of some human agency, it will be contract of indemnity. And if it will not be because of the human agency, then it will not be covered under the contract of indemnity. Now I hope the point of insurance is covered. Yes, yes, Chaitanya. Okay, if I generally say that, okay, which kind of life insurance? Life insurance is what kind of contract? That is the contingent contract only from the perspective that might be A will die, might be A will not die. But if I'll take the liability point, in that case, liability will definitely happen. Life insurance company are always liable to pay you. The only difference is if the contingency took place, they will be liable to you paying before the maturity time period. And if the contingency will not take place, they will be liable to pay you at the maturity time period. कुमार प्लीज रिपीट योर डाउट बच्चे, मेरे को समझ नहीं आया, एक बार क्वेश्चन दोबारा लिखो. Okay, now moving on. Next, modes of creation of contract of indemnity. Like any other contract, जैसे आपने पहले भी पढ़ा होगा, द कंट्रैक्ट ऑफ इंडेमनिटी कैन ऑल्सो बी एंटर्ड by the express words. Now, express means it can be in the written form between the indemnified and the indemnity holder, or it can be through some oral conversation. Written or oral means you are expressing you out by writing or by verbally. This is the express contract. And in implied contract, maybe because of your some gestures, your body language, your gestures, you have not written anything, you are not saying anything, verbally you have not communicated with with each other, but because of your body language, because of your gestures, because of your demeanor, the other person comes to know about that there is a contract. इसकी एग्जाम्पल करते हैं एक. For example, so there was one ship in the sea, and the owner of the ship always used to take the insurance of the ship from particular company, general insurance company. First year, he entered into a contract writing owner and the insurance company. Second year, there was a proper written contract. Third year, there was a proper written contract. And in the fourth year, the insurance company and the owner delayed in doing the legal formalities of writing the contract. They just delayed the formally writing of the contract. And meanwhile, ship capsizes. Ship sinks into the water. Now this owner is asking this insurance company to give the compensation. But this insurance company says that we don't have any written contract. Owner said, 2 days back I came to you and I told you that legal formalities are yet to be done. The contract is yet to be framed in a writing. It meant that we already had a contract of indemnity. And it's been 4 years we have been entering into this contract, and I am just associated with you. I am not taking this insurance from any other company. So 2 days back, the visit of this owner to the insurance company, 2 days back, showing his willingness to enter into a contract, and a reply from the insurance agent that I'll be doing this soon, right? So they just had the gestures shared with each other, not written anywhere, not verbally communicated to each other. Gestures क्या है? Entering into contracts since 4 years with the same company, going off owner to the insurance company. So these are the ways from where we can say that there was the contract of indemnity, and this insurance company will need to compensate this owner if the ship sinks while these things were there was a delay, but yes, intentionally they already entered into a contract. So express contract is where expressly they have shared with each other, and implied means where from the conduct of the parties, from the body language, from the gestures of the party, it can be said that they entered into a contract. Example dekhte hain. This is the example. They say, just like in the starting of the class, I told you that in a normal type of the contract, all the essentials needs to be fulfilled. Along with that, if that contract is formed, only then that contract will be further formed into the contract of indemnity. So they said, like any other contract, the general principles of contract are also applicable. That is the essentials to make the contract valid. What example says? Now, if you just remember, essentials there is essential that there should be lawful purpose, legal purpose. But if this contract is not legal, this contract is not contract, how can you move forward to make it a contract of indemnity? In the same way, if A asks B, go and beat C, whatsoever will be the consequences, I will save you. Now asking B to go and beat C, it is not the contract for the legal purpose. Accordingly, B went and he beats C. Fine was imposed on B, rupees 1,000. B went to A. Give me those 1,000 rupees, I have to pay the fine. Because you told me go and beat C, whatever will be the consequences, I will give it to you. Now consequences are that rupees 1,000 rupees fine has been imposed on me. Give it to me so that I can give it further. A said, I am not going to give it to you. B said, contract of indemnity enter hua tha. I will sue you. I will file a case against you to recover this 1,000 rupees from you. Court will say you cannot have the compensation of 1,000 rupees from A because this contract was not made for legal purpose. First, it was not the contract even. How can you even ask for the compensation by making it a contract of indemnity? This is your example. किसी को बच्चे अभी तक कोई डाउट है तो प्लीज पूछ लो सो दैट वी कैन मूव फॉरवर्ड. किसी को कोई डाउट है बच्चे? Any person, anyone? Okay, Khadija, no ma'am. Okay. Kavita is asking question that if it does not have written document, how promisee will prove the contract of insurance is made? Kavita, so in law, we follow the Indian Evidence Act. Evidence Act means evidentiary value. एक चीज की एक evidentiary value कोर्ट के आगे कैसे पेश करनी है. नाउ दिस एविडेंशियरी वैल्यू कि ये एविडेंस है किस चीज की पेश हो सकती है. आपके पास कोई डायरेक्ट एविडेंस हो सकता है, जैसे अगर आपके पास कोई रिटन कंट्रैक्ट है तो आप वो कंट्रैक्ट कोर्ट में पेश कर सकते हैं. दैट इज द डायरेक्ट एविडेंस. बट कभी कभी सिचुएशंस आर सच दैट यू डोंट हैव द डायरेक्ट एविडेंस. व्हाट विल यू डू इन दैट केस टू इम्प्रेस द कोर्ट? In that case, you will give the circumstantial evidences. There is a terminology, circumstantial evidences. You will prove the circumstances in the court, and that will be given the evidentiary value, and the court will definitely consider that. So in the case of implied contracts, you will prove the surrounding circumstances so that you can impress the court that there was a contract. Is that clear, Kavita? ओके नेक्स्ट चलते हैं. राइट ऑफ इंडेमनिटी होल्डर. इंडेमनिटी होल्डर मीन्स person with whom the promise is made, that is indemnified. Now the rights are covered in section 125, that is the next section. Indemnity holder के क्या क्या rights होंगे? For example, A promised with B, whatsoever loss you will suffer because of me or because of this third party, I will compensate it to you. Whatsoever loss means all the damages. जो भी नुकसान बी को होगा ए की वजह से या फिर थर्ड पार्टी की वजह से, वो सारे के सारे नुकसान की भरपाई ए से ले सकता है. दिस इज द फर्स्ट राइट, राइट टू रिकवर ऑल डैमेजेस. सेकेंड, राइट टू रिकवर द कॉस्ट ऑफ द सूट. कॉस्ट ऑफ द सूट मीन्स जहां पे सूट फाइल हुआ हो. फॉर एग्जाम्पल, ए ने बी को प्रॉमिस किया कि अगर तुम्हारे, फॉर एग्जाम्पल ए ने बी के अगेंस्ट सूट फाइल किया, सॉरी ए ने बी के साथ प्रॉमिस किया. क्या? अब सिचुएशन क्या थी? बी ने सी से 5,000 रुपीज एडवांस लिया हुआ था. बी ने सी, कोई थर्ड पार्टी है, उससे 5,000 रुपीज एडवांस लिया हुआ था. अब ये बी उनको 5,000 रुपीज पे नहीं कर पा रहा, एंड ए ने बोला डोंट वरी बी, ए सेड बी डोंट वरी, if C will file a suit against you will file a case against you to recover 5,000 from you, I will see. I will compensate it to you. Now, if this C will file a suit against B, तो B have to defend himself. अपने आप को बचाना पड़ेगा उस केस से. बचाने के लिए एडवोकेट करना पड़ेगा, कोर्ट की कॉस्ट पे करनी पड़ेगी, सब कुछ पे करना पड़ेगा. ए कहता कोई बात नहीं, जो भी सूट तुम्हारे अगेंस्ट फाइल होगा सारा खर्चा मैं देख लूंगा. सो here the B will have a right to recover the cost of this suit, cost of this case from A. Now ब्रिंगिंग और डिफेंडिंग मीन्स, हो सकता है ये सूट इसी ने ही फाइल किया हो, बी ने फाइल किया हो सी के अगेंस्ट इन द ऑपोजिट सिचुएशन. इन दैट केस फॉर फाइलिंग, फॉर ब्रिंगिंग द सूट जितनी कॉस्ट लगी वो ए से रिकवर कर सकता है. बट जो एग्जांपल मैंने दी उसमें ही इज जस्ट डिफेंडिंग हिमसेल्फ, अपने आप को बचा रहा है. किसके अगेंस्ट? जो सी ने इनके अगेंस्ट केस फाइल किया टू रिकवर दैट 5,000 रुपीज. बचाने के लिए इस सूट में से, अपने आप को बचाने के लिए जो भी एडवोकेट कॉस्ट, प्रिंटिंग के पैसे, जो भी जितना भी खर्चा आया वो सारा का सारा ए से रिकवर कर सकता है. नेक्स्ट, राइट टू रिकवर ऑल द सम्स. मान लो ये सूट फाइल हुआ, सी ने बी के अगेंस्ट सूट फाइल किया, बट हुआ क्या? सो बी और सी के बीच में कॉम्प्रोमाइज हो गया और सी ने अपना केस कोर्ट से वापस ले लिया. जब इन दोनों में कॉम्प्रोमाइज भी हुआ, कॉम्प्रोमाइज ऑफ द सूट हुआ, बेसिकली एडजुडिकेशन नहीं आई, जजमेंट नहीं आई, दोनों पार्टीज ने कोर्ट में एक दूसरे के साथ समझौता कर लिया, कॉम्प्रोमाइज भी कर लिया ना, तो कॉम्प्रोमाइज में भी जितना बी को सी को देना पड़ा, इन दैट केस जितनी भी अमाउंट बी को सी को देनी पड़ी वो भी अमाउंट वो ए से रिकवर कर सकता है. सो इट डिपेंड्स अपॉन द सिचुएशन, राइट. अगर जो भी डैमेजेस है, जनरल सिचुएशन इज जो भी डैमेजेस, उसको जो भी नुकसान हुए वो इंडेमनीफायर से ले सकती है. बी, अगर किसी ने उसके अगेंस्ट सूट फाइल कर दिया या इसने उनके अगेंस्ट सूट फाइल किया, जो भी खर्चा आया वो ए से ले सकती है. और अगर सूट लड़ते लड़ते दोनों में कॉम्प्रोमाइज हो गया तो कॉम्प्रोमाइज में जो इंडेमनीफाइड को पे करना पड़ा वो भी उससे रिकवर कर सकती है. दीज आर द राइट्स ऑफ द इंडेमनिटी होल्डर. Right? Okay, bache, we'll just take a short break of 5 minutes. Okay, we'll be back in exactly 5 minutes. Just wait. Okay. Chananya, no, bete, it is not covered. So, we'll be just taking a short break of 5 minutes and we'll be back in 5 minutes so that we can continue with the next concepts. point to be covered in the contract of indemnity. As I told you, that indemnity is a part of the contingent contract only. That is, if the indemnified will suffer loss, then only indemnifier will compensate the indemnity holder. Otherwise, if the loss will not happen, obviously he will not compensate it to the indemnity holder. From the same point, if I'll say that when will the indemnifier will get liable? When will the indemnifier will get liable? They say there is no specific provision in the Contract Act, but yes, based upon the judicial pronouncements and based upon the basic understanding. Judicial pronouncement means जो भी judgments पहले judges दे चुके हैं उनको consider करते हुए या फिर वैसे नॉर्मल जनरली भी कंसिडर करते हुए हम ये कंक्लूजन निकाल सकते हैं कि इंडेमनीफायर उसी टाइम लायबल हो जाता है जिस टाइम इंडेमनिटी होल्डर लायबल हो जाए. अब इंडेमनिटी होल्डर लायबल कब होगा? जब जिस टाइम पे इंडेमनिटी होल्डर को लॉस हो गया, that very moment when the indemnity holders will get liable, will be having the losses, will get liable, that this indemnity holder is liable. Now this is absolute and certain. If that contingency has happened, the loss has become absolute and certain. At that very moment now, indemnifier needs to compensate it to the indemnity holder. You can just read this slide for a minute. I'm giving you a minute, bache. So indemnifier's liability commences at that very moment when the indemnity holder's liability becomes absolute and certain. Any doubt till now, bache, to anyone? चलो आगे चलते हैं. मल्टीपल चॉइस क्वेश्चंस. फर्स्ट क्वेश्चन थोड़ा जल्दी जल्दी करेंगे, मुझे आप आंसर देंगे. indemnity contract, what is the primary purpose of this indemnity contract? To provide a loan, to compensate for damage or losses, to transfer the ownership of the property, or to create a partnership? Yes, very good. Okay. I'll just see who else have given the answer. Okay. Everybody is right. It's good to see. Nana said B, Shoaib said B, Kanika said B, and then Ashwika said it's B, Krish said it's B, Satyam and Yash said it's B, Nana said it's B, to compensate for damage and losses. Palak Jain said it's B, Riya, Nandini, Chaitanya, Ansupa, Satyajit, Natasha, Niharika, Ayushi, Chandni, Aryan, Kumar, Palak, Bhardwaj. Very good. Let's move on to the next question now. So here in the picture, even you can see that the compensation is being to this girl for the loss she has suffered. So it is B, to compensate for damages or the losses. Okay. A contract of indemnity is a void contract, a quasi contract, a contingent contract, or a wagering contract. Let's see the answers now. Okay, good. Okay, Satyajit said it's C, that is the contingent contract. Shoaib, Kanika, Yash, Nana, Riya, Palak, Ashwika, Krish, Niharika, Satyam, Chaitanya, Amit, Ayushi, Palak, Aryan, Natasha, Chandani, Princey, Ansupa. It's very good to see that everyone has answered rightly that it is C. Okay, Palak is saying C, Isha is saying C, that is, it is the contingent contract. It's the subset of the contingent contract, part of the contingent contract. Let's see the next question. A contract of insurance which does not provide for the payment of the fixed amount. पेमेंट ऑफ द फिक्स्ड अमाउंट के लिए एक इंश्योरेंस का कंट्रैक्ट है, इट इज नॉट प्रोवाइडिंग अबाउट द पेमेंट ऑफ द फिक्स्ड अमाउंट. इट मीन्स आई एम नॉट टॉकिंग हेयर अबाउट द लाइफ इंश्योरेंस, क्योंकि लाइफ इंश्योरेंस में वी गेट अ फिक्स्ड अमाउंट. But according to the loss suffered by the injured person is a contract of indemnity, a contract of guarantee, wagering agreement, or the contingency contract. जितना लॉस होगा उतना पे करूंगा, तो वो इंडेमनिटी होगा, कंट्रैक्ट ऑफ गारंटी होगा, वेजरिंग होगा, या फिर कंटीजेंसी होगा. ओके, रिया सेड इट्स ए. वेरी गुड, बिकॉज जितना लॉस होगा उतना कंपनसेट करेंगे. एवरीबडी सिंग ए. वेरी गुड. पलक, अंशुपा, कुमार, प्रिंसी, प्रगति, वेरी गुड. नेक्स्ट वी आर हैविंग निहारिका, नैना. Everybody has answered. It's a contract of indemnity. Chandani also said it's a contract of indemnity. But no doubt, if the loss will happen, only then it will compensate. It's the contingency contract also. But अगर हम specifically बताएं कि उतना ही loss, contingency contract also, but यहाँ पे fixed amount की बात कर रहे हैं, तो fixed amount means we are not covering here life insurance or some other fixed type of the thing. If this contingency will happen, this fixed amount will be given to you. That can be the contingent contract. But in the indemnity, only based upon your loss suffered, you will be compensated. That is why it is specifically a contract of indemnity. Satyajit, yes, Satyajit has also answered very well. Let's move on to the next. In a contract of indemnity, how many parties and how many contracts are there? There are 3 parties, 1 contract, 2 parties, 2 contracts, 3 parties and 3 contracts, 2 parties and 1 contract. Yes, I am just expecting answer from everyone, bache. Very good. Everybody is answering it very well. Manasvi, it's not B, bete. In B, it's 2 parties and 2 contracts. In contract of indemnity, it's only 1 contract. But yes, the 2 parties. Okay. So, okay, Ashvika has said it's D. Kanika said it's D. Riya said it's D. Pragati said it's D. Natasha, Kumar, Sadi, Palak Jain, Satyam Dubey. It's all D. Sadi, it's not B, bete. In B, it is written 2 parties and 2 contracts. 2 parties tak to theek hai, you are right. But these are not 2 contracts. It's a single contract between the indemnity holder and the indemnifier and the indemnity holder. Yes, Prince, it's D. Palak, it's D. Chandani, Shoyab, everybody is answering rightly. It means you are understanding the concept. Very good. Next, let's move on to the next question. What happens if the indemnity holder intentionally causes the loss? What happens if the indemnity holder with whom the promise has been made, that is the indemnity holder, अगर वो खुद intentionally loss करता है तो क्या होगा? Indemnifier is still obligated to pay for the loss. The indemnifier is released from the liability. The indemnity holder can claim double compensation. The indemnity contract is automatically voided. क्वेश्चन ध्यान से सुनो, लिटिल टेक्निकल क्वेश्चन. हमने इंडेमनिटी में क्या बोला था? इंडेमनिफायर इंडेमनिटी होल्डर से प्रॉमिस करता है दैट इफ यू विल सफर लॉस बिकॉज ऑफ मी, इंडेमनिफायर कहता है अगर मेरी वजह से या किसी थर्ड पार्टी की वजह से लॉस होता है तो. और हमने स्पेसिफिकली किया था अगर प्रॉमिसी का अपनी गलती की वजह से लॉस होता है तो इंडेमनिफायर उसको कंपनसेट करने के लिए लायबल नहीं होगा. इट इज नॉट कवर्ड अंडर इन द इंडेमनिटी कंट्रैक्ट. So what should be the answer? Now read the options properly and give me the answer. Yes, very good. It's B, that is the indemnifier will be released from the liability because the loss has not happened because of the indemnifier himself or because of the loss because of the mistake of the third party. So Palak Jain rightly said it's B. Krish said it was intentionally. Even it is intentional or non-intentional, if it is because of the promisee himself, that is the indemnity holder himself, he will not get compensation. He will not be covered under the contract of indemnity. Okay, Princey said it's B. Krish said it's B. Kanika said it's B. Then we are having Ansupa, it's B. Shoaib, it's B. And then we have Pragati, it's B. Kumar, it's B. Yes, I hope now you have got the point what I am saying, that it is because of the indemnity holder himself. It is not covered under the indemnity. So accordingly, the indemnifier will be released from the liability. He need not to compensate the indemnity holder. Okay. Again, a one situation based question. Raisa, who is the owner of a shipping company. Raisa is the owner of the shipping company. He entered into a contract of indemnity with a client Sifa. So Raisa is the owner and Sifa is the client. Where Raisa agreed with Sifa that Raisa will compensate Sifa if any of her goods are damaged during the transit. So Sifa was transiting her goods through the ship whose owner was Raisa. And Raisa promised with Sifa, don't worry, if any damage will happen with your goods while transit, I will compensate it to you. Now, a week later, due to storm, one of the ships transporting Sifa's good capsizes. Capsizes means just sinks into the water only. And she suffers significant financial losses. Sifa ko financial loss hua. What should Raisa do? Raisa is not liable because the loss was caused by the natural forces. Raisa must compensate Sifa for the loss. Raisa can refuse to compensate because the contract did not mention weather conditions. Raisa should contact the ship manufacturer for the compensation. Yes, it's B. That is, Raisa must compensate Sifa for the loss. It cannot be C, that is, weather conditions were not mentioned. It cannot be covered under the natural forces because I told you that the marine insurance and the fire insurance is covered under the contract of indemnity. So this is the type of the marine insurance. So here, Raisa must compensate Sifa for the loss. Yes. Palak Jain has rightly said it's B. Kumar said it's B. Chandani said it's B. Then Ashwika said it's B. Okay. I hope you all are understanding the concept. Let's move on further to the contract of guarantee now. Be attentive. We are starting with the next type of the contract of indemnity. Now in we are starting with the contract of guarantee. We have just finished with the contract of indemnity. Contract of guarantee. एक simple सी example करते हैं. For example, we see many kids begging on the roads. And they ask you that if you don't want to give money, please get us an ice cream. Please get us a water bottle. Please get us something from this shop if you don't want to give us some money. So, for example, a kid was begging. And I said, I will not give you money. If you want to eat something, you can come with me to the shop. He said, ma'am, please get me an ice cream. I said, okay, come with me. I took that kid to a ice cream parlor and I asked the vendor, please give this ice cream to this kid. Don't worry, I will pay for him. Don't worry, I will pay for him. Here, I am giving the guarantee to this vendor. Don't worry, give him an ice cream. I will pay for it. I am giving a guarantee to this vendor कि जो भी आपकी payment बनेगी, I will pay it to you. I am giving a guarantee to this vendor. Now, actually, वो आइसक्रीम किसने खाई? उस बच्चे ने खाई, उस किड ने खाई. तो एक्चुअली वो अमाउंट, वो पैसे किसको देने थे? उस किड को देने थे। तो एक्चुअली वो अमाउंट ड्यू किससे हुई थी? उस बच्चे से। सो दैट किड इज अ डेटर हेयर, हु ओज अ डेट, जिसको पैसे देने थे। तो दैट पर्सन इज अ डेटर हेयर। एंड द पर्सन हु गिव्स अ क्रेडिट, क्रेडिट मीन्स उधार दे दिया थोड़े टाइम के लिए, क्रेडिट दे दिया। किसने दिया? वेंडर ने, आइसक्रीम पार्लर के ओनर ने दिया। तो बेसिकली जिसको पैसे देने हैं वो डेटर हुआ, और जिसने पैसे लेने हैं ही इज अ क्रेडिटर। द पर्सन हु ओज मनी इज अ डेटर, एंड द पर्सन टू whom द मनी इज ओड इज अ क्रेडिटर. Now I don't owe money, and I don't need, I will not be even a receiving money. I am just giving a guarantee that okay, if this kid will not give it to you, I will give it to you. That I am giving a guarantee. Primary responsibility उस मनी को देने की किसकी बनती थी? जिसने, जो डेटर है, जिसका देना बनता है, दैट इज दैट किड. बट इफ दैट किड विल नॉट गिव, आई विल गिव. I am giving the guarantee. I am giving the surety. Don't worry, your money will not go anywhere. I will pay you. So the person to whom this guarantee is given, that is the creditor. And the person by whom this guarantee is given is the creditor, is the surety. I am giving this guarantee. And the person for whom I am giving the guarantee, that if he will not discharge the liability, I will discharge. The person for whom I am giving the guarantee is a kid. That is the debtor. सो इसको हम अब कंसेप्ट वाइज पढ़ेंगे, डेफिनेशन वाइज पढ़ेंगे. सो अ कंट्रैक्ट ऑफ गारंटी मींस अ कंट्रैक्ट. अब कंट्रैक्ट किस में एंटर हुआ, आगे पढ़ेंगे. मींस अ कंट्रैक्ट टू परफॉर्म द प्रोमिसेस मेड और डिस्चार्ज द लायबिलिटीज ऑफ द थर्ड पर्सन इन केस ऑफ हिज डिफॉल्ट. So here, a person who will discharge is a surety. I will be the surety. In case of default of this kid, in case of default by this debtor towards the creditor. So here we will be three parties: creditor, principal, debtor, and the surety. Let's take this example from the picture itself. A wanted to buy a car. He is the dealer. He said, okay, I will sell a car to you, but I want a guarantee. Because if you will not pay, what will I do? Dealer said to A, okay, I will be giving a car to you, I will be selling a car to you, but if you will not be paying for car to me, what will I do? I want a guarantee. I want a guarantee means if you will not be able to pay, I can recover it from some other person. Give me some guarantee. Please bring some surety to me. Who will take a surety that if A will not be able to pay, I will pay. So if A will not discharge the liability, I will discharge the liability in place of A. So here, A brought a surety who said to the dealer, don't worry, give this car to my friend A, and if he will default, he will not be able to pay, I will pay in place of him. Now B, who is saying that I will pay if A will be doing a default. He is a surety. He is assuring the dealer. Now, actually money is owed by A to B. Debt is owed from A. He is a debtor. To whom the money is due? The creditor. A person who is giving a guarantee is a surety. So he is saying, give a card to my friend A. And if A will not pay, I will pay. So here, what surety is doing? He is promising with the dealer, with the creditor, to discharge A's liability in case A will do a default. So can I say primary liability debtor की ही है, पर अगर वो पे नहीं करेगा तो सेकेंडरी लाइबिलिटी किसकी आएगी? श्योरिटी की आएगी. तो पहले ए ही पैसे देगा, और अगर ए पैसे नहीं देगा तो फिर बी को देने पड़ेंगे. एनी डाउट टिल नाउ? Himanshu, I'll get back to this point tomorrow. आफ्टर एक्चुअली लुकिंग एट दी वोकेबलरी इन हिंदी, मैं आपको फिर बताऊंगी कि इसको एक्चुअली में प्रॉपर वर्ड क्या है, श्योरिटी को बोलने के लिए हिंदी में प्रॉपर वर्ड क्या है, वो आई विल सी एंड आई विल गेट बैक टू यू इन द नेक्स्ट क्लास. Okay, Ansupa said no, ma'am. Anybody is having any doubts, so we can move forward. Okay. I hope you all are understanding the concept. Okay, okay. ठीक है हिमांशु, नेक्स्ट चलते हैं. अब पार्टीज टू कंट्रैक्ट ऑफ गारंटी कौन हुआ? सो कंट्रैक्ट ऑफ गारंटी क्या है ये तो हमने एक्सप्लेन कर लिया. उसके बाद हम करेंगे पार्टीज टू कंट्रैक्ट कौन है, वो मैंने आपको बता दिया. 3 पार्टीज होंगी, क्रेडिटर, डेटर एंड द श्योरिटी. श्योरिटी, सो डेटर इज द पर्सन in respect of whose default the guarantee is given. For whom the guarantee is given is a debtor. Who is giving the guarantee? The surety, the person who gives the guarantee. And to whom this guarantee is being given? That is the creditor. So he's the debtor, he's the creditor to whom the guarantee is given. And by whom the guarantee is given? Contract is in the hand of surety. He is checking कि जो मैंने गारंटी दी है वही उस पर लिखी हुई है ना, because he need to check that I will be liable only for these points written in the contract. Okay. Now, contract of guarantee is a tripartite agreement. In effect, there are 3 contracts. 3 contracts कैसे? First contract, actually amount किससे ड्यू है? डेटर से. किसके टुवर्ड्स ड्यू है? क्रेडिटर से. सो द अमाउंट इज ड्यू फ्रॉम द डेटर टुवर्ड्स द क्रेडिटर. सो दिस इज द प्राइमरी कंट्रैक्ट. प्रिंसिपल कंट्रैक्ट क्या है? दैट द अमाउंट इज ड्यू फ्रॉम द डेटर टू द क्रेडिटर. सो बिकॉज द क्रेडिटर मस्ट हैव गिवन समथिंग टू डेटर, that is why now debtor owes something to the creditor. This is the first contract. So contract of guarantee consists of 3 types of the contract. These 3 contracts are the contracts of guarantee. Why these 3 contracts? Because in these particular 3 contracts, everybody owes, everybody have some rights or duties towards each other. For example, in first contract, that is the principal contract between the debtor and the creditor is having a right to recover the money from the debtor, and debtor is having a duty to give a money to the creditor. So principal contract is between the debtor and the creditor. Secondary contract is between the surety and the creditor, where the surety gave a guarantee to the creditor. Don't worry, if he will not pay, I will pay. This is the secondary contract. Third contract, implied contract. Why it is implied contract and what this third contract is, listen to it very carefully. Now, if the surety, for example, debtor did a default, now surety will definitely compensate it to the creditor because he has given a guarantee. For example, surety has given the amount whatever was due from the debtor to the creditor. But एक्चुअली में क्या श्योरिटी ने डेटर का कुछ देना था इसलिए उसने पे किया? नो, श्योरिटी हैज जस्ट गिवन अ गारंटी फॉर द डेटर. सो इफ श्योरिटी हैज fulfilled the obligations, fulfilled the liabilities in place of debtor towards the creditor, surety should also get the amount whatever he has paid on behalf of the debtor. So to recover that amount, whatever surety has paid on behalf of the debtor, he need to recover it from the debtor. So they say wherever there is a contract of guarantee, though it has not been discussed between the debtor and the surety, that the debtor would have said that, okay, you if you will pay, I will pay to you. Even if it has not been said in the contract of guarantee, it is implied contract. Automatically, whenever the contract of guarantee has been entered and the surety has given the guarantee to the creditor for the debtor, automatically, if the surety will discharge the liability to the creditor on behalf of the debtor, surety will be having a right to get the recovery of all whatever he has given to the creditor on behalf of the debtor. And the debtor has to give it to the surety. And for that, surety can even file a case against the debtor that, okay, I have given this money on behalf of the debtor. I gave the guarantee and now he is not giving it to me. Now, surety will say in the court, what proof will you have? Surety will give the contract of guarantee in the court. And debtor will say, nowhere it is written that I will be recovering it to you. Then the court will say, it's the implied contract. Even though you have not expressly exchanged the terms with each other, this is the implied contract. You have to recover the creditor because he has paid on behalf of you. So in this contract of guarantee, there are three types of the contract. These three contracts are here only. So whenever there is a contract of guarantee, it means there must be a principal contract between the debtor and the creditor. It means there must be the secondary contract between the creditor and the surety. And there must be the implied contract between the surety and the principal debtor. If implied contract is not in picture, then surety is done for natural love and affection. Okay, Chaitanya, in the contract of guarantee, then it will not be, okay. I'll just explain you with the doubt you have asked. चैतन्य बेटे मैंने आपको जैसे आज का हमने सेशन स्टार्ट किया था when we started today's session I specifically told you that first it must be a contract, only then it will be a contract of indemnity or guarantee, and for contract there must be consideration. For contract there must be consideration. If somebody is doing something out of love and affection, it will not be a contract. And if it will not be a contract, it can never be a contract of guarantee. I hope that your doubt is clear regarding you said that if implied contract is not in picture, then surety is done for natural love and affection. If there is natural love and affection, that will not be a contract of guarantee. There is a consideration here that we will be reading in the next slides and you will get it more clear. Okay, example करते हैं. XYZ Limited एक small business है and XYZ Limited wanted to take a loan from ABC Bank. But ABC Bank saw that XYZ Limited's business is at high risk and he don't want to give a loan to XYZ Limited. But then XYZ Limited requested ABC Bank to please give a loan to their business. ABC Bank said, okay, I will give a loan to you, but please bring a guarantee for us. Guarantee for us means if so ever you will not be able to pay, in that case, we will be able to recover it from the surety in case you will provide a guarantee. So XYZ Limited asked their owner Raghav to give a guarantee. Raghav gave a guarantee. Now here Raghav is a surety. ABC Limited, who will give a credit, is a creditor, and XYZ Limited, who will owe money to the bank after taking a loan, is a debtor. So now if Raghav will give a guarantee, ABC Bank will give a loan to XYZ Limited. Now ABC Bank, if gave a loan to XYZ Limited and XYZ Limited actually defaults in paying the money of the loan, repayment of the money के लिए default कर दिया XYZ Limited ने. Now ABC Bank can ask the Raghav, that is surety, for the responsibility of repaying the entire amount, as the Raghav was the surety and gave a guarantee to the ABC Bank for XYZ Limited. In the same way, in the next example, Ch2-The Enterprises is a manufacturing company. It signs a deal of rupees 2 lakh with the raw material provider. So a raw material provider and Ch2-The Enterprises entered into a deal where raw material provider needs to provide raw material of rupees 2 lakh rupees to this manufacturing company, Ch2-The Enterprises. But since this raw material provider was unsure that whether this Ch2-The Enterprises will be able to pay for this raw material of 2 lakh rupees, he was in doubt. They said, you have to give a guarantee, only then we will supply a raw material of 2 lakh rupees. That in case we will not be able to recover this amount from you, we will have a guarantee, we will have a surety. So Ch2-The provided a guarantee Of whom? Rexin Corporation, which was the parent company of Ch2-The Enterprises. So now this raw material provider said, okay, now I will be providing you the raw material of 2 lakh rupees, because now we know that if you will not repay us, we can ask the Rexin Corporation to repay the unpaid bills. So if here the Ch2-The fails to pay the unpaid bills, the raw material provider can ask its parent company, Rexin Corporation, which gives the guarantee, who is a surety also, that you will have to pay us for the supply of raw material we made of 2 lakh rupees to Ch2-The Enterprises. He is not able to give us the money. Now you have to give us, because you gave the guarantee for them. These are the two examples. I'm giving you a minute to read it. You can read it. If you have any doubt, you can ask me, bache. Nana Verma, if there would have been a guarantor, definitely it would have been his responsibility. Please read it, bache. Okay, आगे चलते हैं. Essential features of a valid guarantee. Okay, valid guarantee होने के लिए, that this guarantee is valid. First point is, there must be a principal debt. There must be a principal debt. Obviously, if debtor is not owing anything to creditor, why will creditor ask for some guarantee that I will be able to recover it from you or not? See, if there will be some person who owes something to me, I will ask the guarantee from him only, that if you will not pay, from where will I recover? But if the debtor, if there is no debt, there is no debtor, for what purpose I will ask for the guarantee? I will not ask for the guarantee, because if you don't owe anything to me, why would I ask for the guarantee for you? If I don't have any recoverable debt from you, मेरे आपसे कुछ रिकवरी ड्यू नहीं है, तो मैं आपसे कभी भी किसी चीज की गारंटी नहीं मांगूंगी. मैं क्यों गारंटी मांगूंगी? मैंने आपसे पैसे लेने हैं. अगर आप नहीं दोगे तो गारंटी दो, कौन देगा? बट अगर मैंने आपसे पैसे ही नहीं लेने, एग्जिस्टिंग डेट ही नहीं है, तो मैं क्यों आपसे गारंटी मांगूंगी? सो फर्स्ट इसेंशियल इज दैट देयर मस्ट बी अ प्रिंसिपल डेट. बच्चे प्लीज रीड कर लो प्रिंसिपल डेट का पॉइंट फॉर 2 minutes. Next, consideration. जैसे in any other type of the contract, we have consideration. We have to give something in return. In the contract of guarantee also, there must be consideration. Direct consideration ho, indirect ho, hardly matters. But there must be a consideration. It should not be out of love and affection. So what they say, okay, tell me one thing. A surety is providing a guarantee that you supply this thing to A. If A will not give it to you, I will give it to you. Now what A is, so what surety is saying? You provide this raw material to A. If A will not be able to give it to you, I will give it to you. I will pay for it. They said, surety is saying I will pay for it. What surety is getting in return? Nothing. What I am getting in return? Nothing. Kehte no. Surety must be having some interest, must be having something in his hand in return. Only then it can be contract. Kehte okay, then what will be the consideration for surety? Is surety getting anything in return? Kehte yes. Kehte what? What surety wanted? Please supply this raw material to A. So for me, the consideration is that raw material provider agrees to supply raw material to A, and that's all I wanted. So what I wanted is, what I got in return, that the raw material has been supplied to A. That is my consideration. So though it's not the direct consideration, it is not a direct consideration paid to me by the creditor, but it's the indirect consideration. It will be a consideration, and accordingly, this is a contract. Example में देखते हैं. Okay, one thing, a very important thing. This consideration should be a present consideration, should not be a past consideration. इसी एग्जाम्पल को पास्ट कंसिडरेशन में लेके चलते हैं. I asked, so raw material provider already provided a raw material to A, already provided a raw material to A without my guarantee, without asking A to provide a guarantee, without asking me to come as a surety. He already provided it. And later on, after 2 months, he said, I provided this raw material to A. Now you provide me surety. I said, you provided raw material 2 months back, and now you are asking for the guarantee. Now you are asking me to come as a surety. He said, okay. I said, okay. No, this cannot be a contract of guarantee. Why? Because for me, the consideration was that the raw material provider will supply raw material to A, but it has already been provided. The consideration is past consideration. And if it is a past consideration, it is not a valid contract, because past consideration is no consideration. And if there is no consideration, that will not be a contract. Then the question of contract of guarantee will never arise. So अगर एक चीज कंसिडरेशन का होना जरूरी है, मतलब मुझे इन रिटर्न कुछ मिलना है, ये जरूरी है कंट्रैक्ट में. कहते हैं आप श्योरिटी हो, आपको इन रिटर्न क्या मिला? मैंने कहा कुछ भी नहीं. कहते कुछ तो मिला होगा, नहीं तो ये कंट्रैक्ट नहीं कहलाएगा, क्योंकि कंट्रैक्ट का इसेंशियल है कंसिडरेशन होना जरूरी है. तो मैंने कहा अच्छा, मैंने कहा मेरे लिए कंसिडरेशन ये है कि मैं चाहता था कि रॉ मटेरियल सप्लायर ए को रॉ मटेरियल प्रोवाइड कर दे. मैं श्योरिटी बनी, मुझे इन रिटर्न क्या मिल गया कि रॉ मटेरियल प्रोवाइडर ने मेरे श्योरिटी बनने पे मुझे इन रिटर्न ये दे दिया कि उन्होंने ए को रॉ मटेरियल सप्लाई कर दिया. मेरे लिए ये कंसिडरेशन हो गया. आई गॉट दिस थिंग इन रिटर्न. बट अगर ऑलरेडी रॉ मटेरियल प्रोवाइडर ने ए को 2 महीने पहले ही रॉ मटेरियल प्रोवाइड कर दिया था, एंड आफ्टर 2 months ही इज कमिंग टू मी, ही सेइंग आप प्लीज गारंटी दे दो, मैं बोलूंगी दे देती हूँ. नो, कंट्रैक्ट में ये वैलिड नहीं है, क्योंकि मैंने उनको बोला. मेरे लिए फिर इसमें कंसिडरेशन क्या होगी? कहते मैंने उनको रॉ मटेरियल प्रोवाइड किया, तो मैंने कहा आपने तो 2 महीने पहले ही रॉ मटेरियल प्रोवाइड कर दिया था. दिस इज नॉट अ प्रेजेंट कंसिडरेशन. यू नेवर वांटेड माय गारंटी. इफ यू वुड हैव वांटेड माय गारंटी, तो आप मेरे को पहले बुलाते ना. दिस इज पास्ट कंसिडरेशन. कंसिडरेशन इज पास्ट, नॉट अ प्रेजेंट कंसिडरेशन. मेरे आने से आपने ये सप्लाई नहीं करी, ठीक है. So this is a past consideration, will not be considered as a consideration. So if it is not a consideration, it is not a contract. So question कि ये contract of guarantee होगा कि नहीं, ये तो बाद की बात है. So this question will never arise. So this consideration, this example is same that as is bank ने लोन प्रोवाइड करना था 50,000 का ट्रायोज लिमिटेड को, बट उसको गारंटी चाहिए थी ट्रायोज लिमिटेड के ओनर जहान से. तो जहान ने जब गारंटी दी, एज इज बैंक ने ट्रायोज लिमिटेड को लोन दे दिया. सो नाउ द कंसिडरेशन फॉर जहान इज व्हाट जहान इज गेटिंग इन रिटर्न, दैट ही वांटेड दैट ट्रायोज लिमिटेड शुड गेट अ लोन. ही गॉट इट, एंड जहान consideration is fulfilled, so it's a contract of guarantee. But if Aziz Bank had already extended the loans to Trios Limited before Jahan asked to be a surety, it would be a past consideration, which is not a valid consideration. As a result, the guarantee contract would be void. Any doubt to anyone, bache? Okay, next essential. As I've already told you that there must be a debt. In the same way, existence of the liability, that the debtor owes something to the creditor, it must be there. Only then the surety will give a guarantee for that. No misrepresentation or concealment. They say whenever creditor will ask you to give a guarantee for the debtor, creditor should not misrepresent or conceal anything from you. Misrepresent करना means कुछ गलत बताना, conceal करना means कुछ छुपाना. क्या छुपाना? अगर कोई इमेटीरियल फैक्ट है, कोई फर्क ही नहीं पड़ता उस चीज से, वो मैटर नहीं करेगा. बट मटीरियल चीज को छुपाना या मटीरियल चीज को गलत बताना, इफ द क्रेडिटर हैज टेकन द गारंटी ऑफ द श्योरिटी इन दैट वे, In that case, that guarantee is not a valid guarantee. For example, ABC Bank convinces Mamta to give a guarantee for Tim's Limited. So ABC Bank is a creditor who wanted to give a loan to Tim's Limited. So Tim's Limited is a debtor. So ABC Bank asked Mamta, give a guarantee for Tim's Limited. But while asking for the guarantee from Mamta, ABC Bank falsely assured her that the company is financially stable. So basically, Tim's Limited was not financially stable, but ABC Bank convinced Mamta to be a surety by misrepresenting Mamta, which was not actually true, that the Tim's Limited is financially stable. Otherwise, the Tim's Limited was not financially stable and it was struggling and was on the verge of bankruptcy. Mamta gave a guarantee, but Mamta gave a guarantee on the misrepresentation made by ABC Bank. So now since the bank has misrepresented the critical information, the material information, the guarantee Mamta has provided will be invalid. Had it been about some immaterial fact that the director is going to retire of this company or something, it is immaterial fact. In that case, if it is immaterial and it is not affecting the mind of the Mamta while giving the guarantee, in that case, it will not be covered here. So two things, misrepresentation or concealment, and that too of the material part of the transaction, not the immaterial part of the transaction. Any doubt to anyone? Any doubt to anyone? Okay. Next essential feature of a valid guarantee. Now the guarantee can be expressed or the implied. So writing is not necessary. Oral ho या फिर written ho. Written ho. Joining of the other co-surety is a very important point. I asked, the raw material provider asked me to provide a guarantee. Raw material provider said, I will be supplying the raw material to A only if you will give a guarantee. I said, okay. But I said, I will give a guarantee if this, my friend of mine, Alicia, will also give a guarantee. So I will act as a co-surety. I will give a guarantee. I will be a surety if this Alicia will also become a surety. Now, Alicia never responded. Now this raw material provider provided raw material to A. A did a default. Raw material provider is asking me, because I was a surety. I said, no, I specifically told you that Alicia has to be co-surety with me. If Alicia is a co-surety, I will pay. Otherwise, I will also not act as a surety. So if this condition has been imposed, this condition has to get fulfilled. Otherwise, I will not be liable to pay. So here in this example also, Grace agrees to act as a guarantor for 1 lakh loan to Cilios Limited. Grace said, okay, I will be a guarantor. I will be a surety for the loan to the Cilios Limited. If Cilios Limited will do a default, I will pay. But Grace also gave a condition that I will be a guarantor only if Sifa will also join as a co-surety. अगर Sifa भी as a co-surety आएगी, मैं तो ही join करूंगी, मैं तो ही guarantor बनूंगी. However, Sifa never signs the agreement. However, Sifa never became a co-surety. Now, since the guarantee was conditional, condition थी, जो condition पूरी नहीं हुई, upon Sifa's participation, and she did not join, Grace guarantee is not valid. You cannot ask the Grace to compensate 1 lakh rupees in case Cilios Limited will do a default in the repayment of the loan. Okay. Now we have a types of guarantee, a specific guarantee and a continuing guarantee. Okay, if the co-surety join, then is the liability is on the part of both the co-sureties? Nana Verma is asking. Yes, bete, both the co-sureties will be liable. अब दोनों की liability कितनी होगी ये हम आगे slides में पढ़ेंगे. But yes, they will be definitely liable. Both will be liable. If there are 3 co-sureties, 4 co-sureties, everyone will be liable. Okay, so now the guarantee is of two types: specific guarantee, continuing guarantee. Specific guarantee is only for a single transaction, single debt, and continuing guarantee is series of transaction. So for example, specific guarantee, A ने guarantee दिया, A guarantees for the payment of 1,000 to B, a mobile dealer. So B was a mobile dealer. A gave a guarantee to this B, a mobile dealer, of rupees 1,000 rupees for the mobile to be supplied to C. So if B will supply a mobile to C, A gave a guarantee that if C will not pay you, I will pay. But the guarantee is only up to 1,000 rupees. So for example, if you will be providing a mobile of 4,000 rupees, I will be only paying 1,000 rupees. I will not pay for full 4,000. For a single transaction, this guarantee was given. B supplies a mobile of 1,000. So B ने अब mobile of 1,000 rupees ही C को supply किया. Now C ने default नहीं किया, debtor ने default नहीं किया, and he pays for it, which C pays for. Now for a single mobile, a guarantee was given. Later B supplies a mobile worth rupees 2,000. Later again B supplied the another mobile of 2,000 rupees. Now C defaulted, that is debtor defaulted. Since they said, A said, now B is asking A to give a money of 2,000 rupees. A said, I gave a guarantee only for a single transaction, that too for the 1,000 rupees. That single transaction already took place and C already gave that 1,000 rupees to you. For the further mobile you are providing, I only gave a guarantee for a specific transaction. I am not liable for the further mobile you have supplied of 2,000 rupees. I am not liable for the second transaction of 2,000 rupees because the guarantee was only for a single transaction. कंटिन्यूइंग गारंटी के एग्जांपल करते हैं. अगर A guarantees a payment of rupees 1,000 to B, a mobile dealer, for any mobile supplied to C over the course of each year. So यहाँ पे अब A ने जो गारंटी दी है B को, मोबाइल डीलर को, कि आप हर साल C को 1,000 रुपीज का एक मोबाइल दे दिया करना, हर साल का एक मोबाइल, उसकी गारंटी मैं देती हूँ 1,000 रुपीज तक की. So if C will not pay you, I will pay you. B supplied a mobile to C. B ने C को मोबाइल सप्लाई किया and C ने उसके लिए पे कर दिया. No default. Later B supplies another mobile of 2,000, but C fails to pay. Later means next year. Each year में एक ही मोबाइल. So later next year again B supplied a mobile of 2,000 rupees. Now C did not pay for it, fails to pay. Now for the next year also, A gave a guarantee because it's the continuing guarantee. So A will be liable to pay if C will not pay. But here the mobile was for 2,000 rupees and A gave a guarantee only for 1,000 rupees. So for the next transaction also A will be liable because it is a continuing guarantee. For the next year also it will work. But yes, he will be liable only up to the extent of 1,000 rupees because the guarantee was only up to the 1,000 rupees. So I hope the specific guarantee and the continuing guarantee is clear. The so one other point of differentiation between specific guarantee and continuing guarantee is, specific guarantee में जैसे मैंने अभी आपको एग्जांपल बताई, जब एक ही ट्रांजैक्शन के लिए थी, सी ने उसको लिए पे कर दिया, now the surety is discharged. Now surety is not liable. Surety is liable comes to an end when the granted debt is duly discharged. अगर डेटर ने ड्यूली उसको डिस्चार्ज कर दिया है तो भी श्योरिटी की लायबिलिटी खत्म है, या उसने अपना प्रॉमिस परफॉर्म कर दिया है तो भी श्योरिटी की लायबिलिटी खत्म है. और मान लो यहाँ पे सी डिफॉल्ट कर देता है फर्स्ट ट्रांजैक्शन के लिए ही, तो श्योरिटी अपनी लायबिलिटी सिर्फ फर्स्ट ट्रांजैक्शन तक के लिए ही रखेगा. पर यस, श्योरिटी की लायबिलिटी फर्स्ट ट्रांजैक्शन के लिए भी खत्म हो जाती है अगर डेटर उसको अपने आप डिस्चार्ज कर देता है. कंटिन्यूइंग गारंटी वो चलती रहती है, जैसे मैंने अभी आपको बोला, हर साल एक मोबाइल 1,000 रुपीज का देना, वो हर साल के लिए एक 1,000 रुपीज की गारंटी है, चलती रहेगी. बट कब तक चलती रहेगी? मान लो 5 साल चलती रही, 6 साल चलती रही, 7 साल चलती रही. आफ्टर 7 years surety took back his consent and said I will no more be a surety. He revoked his surety. रेवोकेशन ऑफ द गारंटी. अब रेवोकेशन कैसे कैसे हो सकती है, वो कैसे कैसे अपनी गारंटी को रिवोक कर सकता है, मेथड्स ऑफ रेवोकेशन हम आगे करेंगे. सो मान लो 5 साल तक चलती रही, उसने बोला मैं देता रहूंगा हर साल एक एक मोबाइल के लिए 1,000 रुपीज. 5th ईयर के एंड में उसने बोला बस 5th ईयर तक मैंने दे दिया, अब 6th ईयर से मैं नहीं दूंगा. इन दैट केस ही इज जस्ट रिवोकिंग हिज गारंटी, ही इज जस्ट रिवोकिंग हिज कंटिन्यूइंग गारंटी। यहां तक बच्चे किसी को कोई डाउट? I'll just take 5-7 minutes more, bache. Yes, Kumar, it is only one time. Ashok sir, I'm not able to receive the queries on the portal. हाँ जी sir, हाँ जी. Right. Okay. Now the nature and the extent of surety's liability. Surety कितना liable होगा? First point, simple. Whatever will be the liability of the principal debtor, the same will be the liability of the guarantee. The same will be the liability of the surety. For example, he took a loan. A took a loan from ABC bank. He is not able to repay. Now surety will repay. If the interest amount is also due on loan, that is, whatever amount is due on loan by the bank from A, the same amount will be due from me if A will do a default. So it is coextensive with that of the principal debtor. Whatever will be the liability of the debtor, if he will fail to pay, I will be paid. My liability is always secondary, because first the bank will ask A, the bank will ask the debtor to pay. If he will not pay, the secondary nature's liability is mine, that I need to pay. If in case of any default in the document, for example, ABC Bank gave a loan to Z. While doing the documentation of that loan, there was some default. There was some defect in the document, because of which now this bank is not able to recover this money from the debtor. So now if that bank is not able to recover this money from the debtor because of the defect in the document, the bank cannot even recover it from me, because my liability is coextensive with that of the principal debtor. Next, a creditor may choose to proceed against a surety first, unless there is an agreement to the contract. To the contrary, what it is saying, कहते हैं हम यहाँ पे लाइबिलिटी की बात नहीं कर रहे हैं. लाइबिलिटी इज ऑलवेज, प्राइमरी लाइबिलिटी इज ऑलवेज ऑफ द डेटर एंड द सेकेंडरी लाइबिलिटी इज ऑलवेज ऑफ द श्योरिटी. पहले वो डेटर से लेने की कोशिश करेंगे, नहीं देगा तो श्योरिटी आता है, सेकेंडरी नेचर. बट मान लो जो जेड है, डेटर है, उसने पे नहीं किया, तो अब जो क्रेडिटर है वो डायरेक्टली मुझे सू भी कर सकता है, या वो डायरेक्टली केस डेटर के अगेंस्ट भी डाल सकता है. आई एम नॉट आस्किंग अबाउट द लाइबिलिटी. लाइबिलिटी प्राइमरी हमेशा डेटर की है, सेकेंडरी क्रेडिटर की है. मैं सेकेंडरी लाइबल होंगी. बट यस, जब वो पहली बार उनसे लेने गया, उन्होंने नहीं पे किया, नाउ दिस बैंक वांट टू फाइल अ केस. It can file a case for the recovery of the money directly against the debtor or directly against me. It is up to the option of the creditor. So a creditor may choose to proceed against surety first. मेरे अगेंस्ट सीधा केस फाइल कर सकता है, अनलेस मैंने कंट्रैक्ट ऑफ गारंटी में कुछ और ना लिख दिया हो. तो अगर मैंने कंट्रैक्ट ऑफ गारंटी में लिख दिया, अगर डिफॉल्ट होगा तो पहला सूट डेटर के अगेंस्ट ही फाइल होगा, फिर देन इट विल नॉट वर्क, बिकॉज देयर इज एन एग्रीमेंट to the contrary. Otherwise, the creditor can directly file a suit against me. Chaitanya, thank you, ma'am. All clear. Lastly, one is indemnity and guarantee is interlinked. We will definitely doing this point while we will be covering the difference between the two. We will be covering the difference between indemnity and guarantee. Then we will be definitely covering it. Then we will definitely elaborate. Thanks to address the queries and have a good day. Thank you, bache. Okay, we'll be doing just 2-3 multiple choice questions. Okay, be attentive. In a contract of guarantee, which of the best describes the role of the guarantor? Guarantor का role क्या होगा? The guarantor is the party who borrows money from the lender. The guarantor promises to fulfill the obligations if the debtor fails to do so. The guarantor is the party who provides goods or services to the debtor. The guarantor is the party responsible for negotiating the terms of the contract between the creditor and the debtor. क्या होगा आंसर बेटे? Attentively everyone. Ashvika is the option B. बच्चे ध्यान से सुनो. We here the guarantor is not here to negotiate the terms and conditions between the creditor and the debtor. He is here to provide, to fulfill the obligations if the debtor will fail. Yes. Isha, yes, it's B. Nandini, yes, it's B. Krish, it's B, bache. Natasha, bache, I told you why it is not D. Princey, it's B. Isha, it's B. Ria, it's B. Very good. Let's move forward to the next question. Who all are the parties to the contract of guarantee? Lender, borrower and witness, creditor, debtor and arbitrator, surety, creditor and debtor, supplier, customer and mediator. What will be the answer for the second? Who are the parties to the guarantee? Yes, it's C. Satyam said it's C. Chandani, Kumar, Amit, Yash, Ashvika, Ria. Okay, everybody is answering it rightly. Princey. Yes, it's C. That is the surety, creditor, and the debtor. Which of the following best describes the effect of misrepresentation by the creditor on a guarantee? अगर creditor misrepresentation करके guarantee लेता है तो उसका consequence क्या होगा? The guarantee is automatically void regardless of that misrepresentation is material or not. The guarantee remains valid if the misrepresentation was unintentional. The guarantee is invalid if the misrepresentation made by the creditor is material and influences the surety's decision. The guarantee is only invalid if both the creditor and the debtor intentionally misrepresent facts to the surety. ध्यान से पढ़ो ये वाला क्वेश्चन. Yes, it's C. The guarantee is invalid if the misrepresentation made by the creditor is material and influences the surety's decision. Yes, Kanika, Princey, Satyam, Ansupa, Chandani, everybody is answering it rightly. It's C. Kumar, Amit, Natasha, Pragati. Yes, it's C, bache. Let's move forward. Which of the following best describes the role of the surety in the tripartite agreement within a contract of guarantee? Surety ka role best describe the role of the surety. The surety assumes the principal's debtor's obligation only if the debtor requests it. The surety guarantees the repayment of a debt or fulfillment of an obligation in case the principal debtor defaults. The surety is primarily responsible for negotiating the terms of the contract between the creditor and the debtor. The surety is the beneficiary of the agreement and receives payment from the debtor. Yes. Yes, Manasvi, everybody is right. It's B, Satyam, Ashvika, Ria, Ansupa, Natasha, Kumar, Princey, everybody is right. Very good. Let's move on to the next question. Yes, Chandani, it's B, bache. Which of the following constitutes valid consideration in a contract of guarantee? What is the consideration in a contract of guarantee for surety? We have just discussed. It's the past services provided by the debtor to the guarantor, love and affection between the guarantor and the debtor, the creditor agreeing to supply goods or extend the creditor to the debtor, verbal promises made without any exchange of goods or services. Yes, everybody is right. Yes, Krish, it's C. Amit, it's C. Ashvika, bache, it's C. Satyam, Chaitanya, Ria, Chandani, Kumar, Pragati, everybody said it's C. Sadi, it's not D, bete. It's not the verbal promises. It's the, okay, what was the consideration for surety? That the creditor has given the things to the debtor. So Kumar, it's C, good. Pragati, it's C. Okay, let's move on to the next question. Which of the following best distinguishes a specific guarantee from a continuing guarantee? We have just done. A specific guarantee applies to a series of transactions, while a continuing guarantee is limited to a single transaction. A specific guarantee applies to a single transaction or debt, while a continuing guarantee applies to a series of transactions or a continuous obligation. A specific guarantee is revocable at any time by the surety, while a continuing guarantee cannot be revoked. Continuing guarantee can be revoked. A specific guarantee covers all future liabilities of the debtor, while a continuing guarantee is restricted to a set period. What should be the answer? Yes, everybody is right. It's B. Ashvika, Isha, Chaitanya, Natasha, Ansupa, Princey, Ria, Sadi. From your answers, I get to know about that you are understanding the concept. Okay, bache, rest we will continue in the next class from the distinction between the contract of indemnity and guarantee. And for today, that's it for today. If anybody is having any doubt till now, they can ask me. Anybody is having any doubt from today's session, bache? Isha is saying, thank you, ma'am. Enjoyed the session. Okay. Okay, Satyam. Thank you, bache. Question number 5. Sadi is asking about. Thank you, Sapna. Okay, bache. Okay, Natasha. Okay, Krish. Sadi, I'll just take your doubt of question 5th. Bache, in the consideration, I told you what will be the consideration for surety? That what I wanted in return. That a debtor should get what he wants. So if the creditor will extend that thing to the creditor, to the debtor, that will be a consideration for a surety. So that is why for question 5th, the option is the creditor who agrees to supply or extend the creditor credit to the debtor. I wanted this only, and that is in return I got. Is it clear, Sadi, now? Okay, right, bache. Example 8, co-surety. Just give me a minute. Okay, this is co-surety wali example. Here, bache, Grace said, I will act as a surety. I will act as a guarantee for the loan given to Cilios Limited. Grace said to the bank, okay, I will be a surety. You give loan to the Cilios Limited of 1 lakh rupees. But I will only be a surety if SIFA will also join me as a surety. So I will co-surety with SIFA. Only then I will be a surety. उसने condition impose कर दी. But SIFA never entered into an agreement, never signed an agreement. So SIFA never became a co-surety. So because Grace entered into a surety, into a contract of guarantee, if SIFA will come, here SIFA did not come, the condition did not get fulfilled. So here Grace cannot be asked to pay as a guarantor if Cilios Limited fails, because SIFA never joined as a co-surety. Is it clear now? Hanji, is it clear, bache? Kumar, it was your doubt. Okay, bache. Okay. ठीक है, bache. Anybody is having any other doubt, bache? Okay, Kumar. Pragati, a specific guarantee is only for a single transaction, for a single debt, whereas the continuing guarantee is for the series of the transactions. All clear? Okay, bache. Okay, Niharika. Okay, Chandni. Okay, Naina. Chalo. Right, bache. We'll be meeting you in the next class for the next session. Thank you so much. Okay, Kumar. Thank you. Ashok sir, should I leave the class? Okay, bache. So, sir, I'll be just opting for leave, right?